All right. This slide is a bit redundant if you've done the on-demand training. The on-demand governance training from the Federation, which right there is terminology that we throw around, the Alberta Federation of Regulated Health Professionals, the AFRHP, or the Federation, is a group where all 30 colleges come to work together on common projects in the province of Alberta. The Federation has a really good footing now to the point where recently when the government was drafting legislation, they actually approached the Federation looking for collective response to some questions that they had. So it is a good forum. It also helps with sharing costs for projects like this amongst all 30 colleges, and often the bigger colleges foot more of the bill than the smaller colleges. So governance training was built by the Federation for use by all 30 colleges. That's what was sent to you by Christy, and introduced this idea of what governance is. So governance is ultimately the high level structure that governs the organization. So it includes those things there, the policies, systems, structures, and the strategic and operational framework. So you guys as a council are in charge of putting that into place to ensure that your CEO registrar, which we refer to as management throughout this presentation, makes appropriate decisions and takes appropriate actions to operate in an effective and accountable manner. So ultimately what that means is that the board is responsible for putting in that high level structure to give the CEO registrar the direction that they need to know what outcome the board is expecting. Under the why does it matter part of this slide here, we really look at the effects of good governance. So good governance allows for all of these things here: clarity in roles, informed decision-making, informed board interaction. All of these things are really born from the fact that if people understand what their job is, then you don't run a risk of either someone not doing something because they didn't realize it was their responsibility or they had the authority to do it, or people stepping into areas that are not an area that they're responsible or accountable for, and potentially alienating someone else, which creates those difficulties in relationships. Throughout this presentation, you will hear me a lot talk about high level. That is really where the board lives. They live at the top, giving that guidance at a high level, and then the staff underneath your management, your CEO registrar, is really there to work in the weeds on the operations of getting things into place. So thinking about our particular organization, as I said, that on-demand training is really about governance in general. We're trying to look here more at how it applies to the COA. So this is just a basic outline of essentially our responsibilities. So as a single mandate college, the welfare of the public is our primary mandate. And ultimately the public, the patients of our practitioners, have moral ownership over our organization. That's a really important reminder to have at the council table. I would say particularly for registrant members of our council, it can be challenging to remove the hat of practitioner and put on the hat of the organization. So registrants are so used to working in the store, in the dispensary, in the practice with their patients. And really you're going to think about it more from a global perspective. That can be challenging, but that's what we're talking about here, is how we affect the public as a whole, so rather than the individual patient. And then the second piece here is the government of Alberta. So the government really is who we're accountable for in that public protection mandate. So the government sets the regulatory framework that we have to follow. The regulatory framework we'll go over in the second part of the presentation this morning, and that is common between all 30 health colleges in the province. And then the health professions themselves self-regulate. So that's where the college council, you guys, come into the system here. So the health professions self-regulate in accordance with that framework. So that ensures that things are done consistently from college to college. So the governance of the organization has to be carried out within the legislation and regulations that the government sets, as well as the bylaws that the government requires the organization to set. And then the college registrants are participants in the governance of the organization. There's a little bit of a gray area there. Before, when we were college and association, we would have argued that the college registrants also had moral ownership of the organization because they were members of the association side of it. Now, there could still be an argument made for that because we do rely on their fees to support the work of the organization, but ultimately we do answer to the public. So in the end, the big takeaway here is that we work independently, but we are accountable to the government and the people of Alberta. So this is just a brief overview at a basic policy governance model. This is likely similar to what was in your on-demand training, and it comes from John Carver. If you're ever looking to study up on board governance, that's what probably everybody at every college, his books are what we read. So in the policy governance model, the board focuses on these 4 key areas. So again, there's that moral ownership we were talking about in the last slide, the vision, mission, and values, the organizational performance, and then policies that basically dictate how the organization is run. So they're trying to maintain effective linkages to that moral ownership. Again, this is where we note that over the last couple of years, we've transitioned from being a college and association within one organization, and we are now just a single mandated college. So our moral ownership maybe has changed a bit, and there is some lack of clarity there, just to be transparent. We do still have registrants who are quite unclear that we do not advocate for the profession anymore, and our responsibility is solely to the public. So we're trying to work on our communications of that message, but it's also really important at the council table because they've been pretty clear in the legislation that we cannot wade into association issues. And so we have to be careful, and the council members at the table can hold each other accountable to noting, we may be looking at this as an association topic. You'll actually see in the council meeting this morning when we review the draft strategic plan, there's one topic that came up in our strategic planning session, and we've made a little note there that this might not be a college issue, it might be an association issue. So things like that, just keeping that in the back of our minds is important. The council also establishes and monitors the vision, mission, and values, as well as the mission outcomes. So vision, mission, and values is pretty commonly understood. The mission outcomes is an important piece because that's how you guys are able to measure performance. So how the college is doing. It really depends on what we are looking for. Did we get there? And if we didn't, was it reasonable that we didn't get there? The council has to assure effective organizational performance. So that's through those things like monitoring and reporting results, and develop explicit statements of values or policies to be served and observed by the organization. So this is just sort of an overview of really the council responsibilities as a whole. So within that policy governance framework, the board, like I said, focuses on high-level plans, policies, and principles, and then allows the CEO to focus on the operations. So in our structure right now, the person who works directly below the board is called the CEO registrar. So the registrar title comes directly from the legislation of health professions, and CEO is the title that they're given for running the organization. This piece really goes over that the board really does only have one staff member. The board staff member is that CEO registrar, and then the president of the board serves as the linkage between the CEO and the board. That's the model that's been set up. So the board works on the things there, the strategic plan, where are we headed? How are we going to fund those priorities? How will the board work together to determine those things? And how do we function? And then it's passed along to the CEO registrar to operationalize those things into an operational plan, determining resources, including staffing, and then managing that relationship between the president, which is their linkage to the board, and the staff who work under the CEO registrar. So from just a functional perspective, we like to point out technically in a firm governance model, the council would have no interaction with any other staff other than the CEO registrar. But that's not reality for the most part. Ultimately, what wants to be communicated here is the council doesn't have contact with staff members other than the CEO registrar unless it's been established that that's a norm. So for example, you'll be asked today to volunteer for some committee work. And if you're on the registration and competence committee, Ruta Neguse is our staff member who's been assigned for administration to that committee in particular. So the committee chair for that committee does regularly contact Ruta. They go over the agenda together. Maybe they set meeting dates together, things like that. But that's an established, she's been assigned to that committee. So everybody knows that. And similarly, Christy does that with the governance and audit committee. And as I said at the top of this meeting, Christy's always at these meetings. She takes your minutes. She sends your per diem checks. So there would be a reasonable opportunity where you may have direct contact with Christy. We're not trying to say like never talk to anyone, but it is the norm that if there's business that needs to be brought up, that a council member would bring it to the president, and then the president would bring it to the CEO registrar, typically through the executive committee, but that's the idea. You do have a set of council norms. Christy, you can jump in and correct me if I'm wrong on how you have sent any of that information, but I think the council norms live on Basecamp.
They do. Yeah.
Yeah. Okay. So you're invited to take a look at those for sure. Hopefully you already have before today's meeting, but they're there for reference whenever you need them. We also have staff team norms at the college, so they are different, but similar. Ultimately, the COA council members are expected to serve as advocates and ambassadors for that values, mission, and vision that the council has set. So that's your opportunity if you're in that discussion to say that you have an issue with that. Once it's set, there really is an expectation that you will advocate for what is said. Council members will work with fellow council members to fulfill the obligations of the council and make decisions about governance of the organization as a whole. Again, that's that very global perspective. They're expected to keep informed about the organization, its issues, members, and the wider profession. Again, this may be where you might have some time with a staff member. So like I said, I've been pulled aside and asked to demystify a piece of legislation. I'm absolutely happy to do that. That wouldn't be unreasonable because you would be fulfilling your obligation to keep up to date. The other piece of that is just meeting attendance and being prepared for the meeting. So we do try to set all the meeting materials out within a reasonable amount of time that you can go over them. They're expected to treat fellow council members with respect and foster an inclusive environment, which diverse backgrounds and viewpoints are welcomed and valued. Regularly attending council meetings and preparing for those meetings by reviewing materials. So you guys will get used to, we've created a pretty dynamic ahead of meeting schedule based on the feedback of what our council members have said they need. So typically we will post the meeting agenda as soon as it's been approved by the chair, and then we'll populate that card on Basecamp with all the meeting materials as they come in. Ultimately, our goal always is to have the meeting materials posted within with a week's amount of time for you guys to review them before the meeting. And then as far as invitations goes, you will have the meeting dates well in advance. We have actually been scheduling the full year recently. But then if there's changes, even that, like we wouldn't make a change a week before a meeting unless it was some sort of emergency. We did have our registrar get COVID last year, so something like that's unavoidable. Even a meeting change would probably be more than a month in advance typically. Council members are expected to arrive on time to meetings and give meeting discussions full attention by limiting or removing distractions. So as Scott mentioned at the top of this call, we do often meet virtually now. And it can be really challenging to give a meeting your full attention when you're especially on a virtual call. So we just really ask that everybody makes an effort. It does make meetings go faster if everybody's locked in and engaged. So maybe that's the incentive there, but it's just a best effort. Expected to complete action items assigned to the council at meetings and be available to serve as a committee chair or a committee member to support the work of the organization. So you guys will have a good introduction to the committees this morning. I'll go over them in this presentation, but this morning we will be calling for reappointment or appointment of new council or committee chairs, and then reassigning committee participation. That's something we do annually. So then just looking specifically at the role of the president, which also, again, you guys will be voting on at the meeting this morning at 11. The COA president's role is to ensure that the voice of each council member is heard during discussions at meetings. So if you've served on a committee before, you will know that that really just sounds like a chair. That is what it is. The president doesn't have any more power over decision making than anybody else. And in fact, as a meeting chair, it could be argued that they have less because they actually don't get a vote unless there's a tie. So their role there really is to chair the meeting, to monitor meeting progress and ensure discussions remain on topic and are completed in the time allocated, so to keep us on track time-wise, and to oversee and enforce the agreed upon rules of order used at meetings. So if you're familiar with Robert's Rules of Order, we used to adhere to that pretty closely. We don't really bring that up anymore, but if you look at your council norms, there's quite a few things that overlap there, but it's nothing crazy. It's, not speaking over each other, making sure everybody has an opportunity to give their input. It's simple things like that. So this is a look at our committee structure, just to give an idea. The committees essentially work under the council and they help the board complete the strategic work. So they'll do things like exploring projects and getting them to a point of readiness for recommendation to the council. It streamlines the council's work and really makes the council more of just a decision maker rather than doing the work. It is chaired by a member of this council, and then members at large who come from our registrant pool are appointed to the committees as volunteers as well. This is a great opportunity. These committee volunteers become a potential pool of board members, and really it's great for the organization to be developing future leaders in that way. And also it gives great perspective. You know, in our registration and competence committee, it's great to have those registrants there. They're the ones who live it. So it's really helpful to hear from them often. So we have 3 standing committees. The first is the executive committee. This is the president, vice president, and a public member. And then the CEO registrar is there as an ex officio member, so a non-voting member. Ultimately, this committee exists just to address things that come up between board meetings that the CEO registrar either cannot, like does not have the authority to, or doesn't want to, without consultation, make a decision on. It doesn't mean that the executive committee makes decisions behind the back of the rest of council. It just gets brought to them for discussion, and then there's decisions made like, should we put this to a vote right now in between 2 council meetings, or is it okay to table it till the next council meeting? It would be decisions like that get made there at the executive committee. The registration and competence committee is really born out of legislation. The Health Professions Act requires us to have a registration committee and a competence committee. We've combined these into one group, and then we just split the work before that committee. So we do registration work and competence work there. This committee supports regulatory matters and oversight of the continuing competence program. One sort of asterisk here is we used to also have a continuing education committee that was working to produce Con Ed. That was an association function. There are some of the standalone colleges who have figured out sort of it's not a go around, but you can still produce Con Ed as long as it's regulatory in nature. We haven't quite waded into that yet. I anticipate we will when we have a new draft of our standards of practice. We'll offer some education related to the new standards, but we don't do that anymore. This committee is here to oversee the program. So it's things like writing policy related to the program, overseeing the audit process at the end of a cycle. And then the regulatory matters are things like registration decisions, registration and renewal policies. In recent years, they talked about fee payment plans. We offered some structured payment plans because we knew COVID was causing some financial strain on registrants, and so things like that. Also, anything working on regulatory matters such as standards practice, code of ethics, legislative changes, those would come before this committee first for a more robust discussion. They sort of pick through it, maybe pick it apart, maybe see a couple drafts, and then the committee would make a recommendation for it to go to council for approval. At the council table, there will often still be discussion, but it'll typically be, a bit of a quicker discussion because it's already been picked apart at the committee level. The Governance and Audit Committee is our last standing committee, and it's there to review governance matters and financial reporting, again, and make recommendations to the council. So they look at things like governance policy. This committee is also in charge of the nominations process. So our 3 new board members here just went through that. This committee is in charge of that process. And then this committee also sees robust financial reporting every quarter. So they do go over that with our accounting manager, Sharon, and they would just bring any issues of that to the council. We also have ad hoc committees. These are formed for a specific purpose and are disbanded when their mandate is complete. So we could actually have any kind of ad hoc committee. I brought up standards of practice earlier, and we did actually on a previous revision of our standards of practice put together a standalone ad hoc committee for that work. It was just too much work for the registration committee to take on top of their regular work. So we can put together an ad hoc committee for any need, but the ones listed here are those that may be required in accordance with the Health Professions Act. So a complaint review committee is called when a complaint is dismissed and the complainant asks for a review of that dismissal within 30 days with reasons. We have to put together a complaint review committee. Hearing tribunals is when a complaint is referred to a hearing tribunal, and an investigation committee can be put together under Part 4 of the Act as part of complaints and discipline, but we've never used that, but we could. So yeah, like I say, these ones get called together, they do their work, and then they're disbanded. So it's over. There's no regular meetings as opposed to the 3 standing committees. This is a brief look at the policies, and just to give a little bit of an idea of who I don't like to say owns, but who owns the policies. So governing policies are how the council expects the college to be governed. And this really is owned by you guys. So, Christy, I think we have one motion on the table at the council meeting today for a change to a governance policy that was recommended by the Governance and Audit Committee. That's a good example of governing policies that the council has ownership over. Similarly, the finance and audit policies are how the council expects finances to be managed. And again, any changes to this document would be brought to the Governance and Audit Committee and then recommended to the council. Finance and audit policies is really how we run the finances of the organization. Registration and competence policies is really more of a policies and procedures document and pretty much is dictated by requirements and legislation and regulation. That sets the policy. Procedures are really set by staff explaining how the work gets done. So it gives a bit of information on things like the sections within our database. So for example, the regulations tell us the registration categories we have the authority to register people under, and then the procedures expand on that, on how we do that within our database. So those may come for approval to the council, but they're really set by requirements of the legislation. And then personnel policies is, again, if we're using ownership, it's owned by the CEO registrar. So they set policies and procedures, they establish them and enforce them with the staff that works underneath the CEO registrar. As far as, I guess I should touch on the relationship between the council and the CEO registrar is a bit different because you will have a contract or an employment agreement there that's a decision between the council and the CEO registrar as an individual, whereas the personnel policies are applicable to all the staff. We have employment agreements too, but they don't come before council. They're between the CEO registrar and the staff. The last piece I'll touch on when we're talking about personnel is just a bit of an update on the situation we have currently with staff. So our registrar CEO resigned in May, and we have an ad hoc committee right now, a hiring committee, who is working with a recruiting firm to recruit her replacement. So we're in the middle of that right now. So things like that employment agreement will come up when you guys are reviewing or approving the recommendation for the new hire. So next is the annual budget. So setting the budget is an annual exercise of the board. It's prepared, the draft of the budget is prepared based on the strategic plan that's set by council. So the typical order of things is that in January, council will either build a new strategic plan if the old strategic plan is up, they typically run for 3 years, or they will review the current strategic plan to see if it's still relevant or if it needs any revisions. Once that is done, the accounting manager and the CEO will draft the budget based on the strategic plan that's been set or been continued on. They will take it to the Governance and Audit Committee for review, and then that committee will make the recommendation for council to accept it. So that's what you guys will be seeing today at the council meeting. So the budget takes into account best estimates of revenue and expenses in the context of expected operational requirements and potential risks and opportunities that are coming in the next year. So we do our best to look into the future. Sometimes things come up that are totally unexpected, but we try again to look at those potential risks and opportunities and assign funding where we think things may happen or are likely to happen. An approved budget is important because it gives management, the CEO, authority to operate within it without coming back to the board for every decision. This is really important, otherwise we wouldn't be able to get any work done. But just to give you some comfort, the CEO does have to present unbudgeted expense requests to the board when they exceed $5,000. So that's set in your financial policies. So if something comes up that's an unbudgeted expense and it costs $1,000, the CEO registrar can make that decision. If it's over $5,000, they cannot. They would have to bring that to the board for approval. And on the heels of that, only a decision of the board as a whole can change the approved budget. So again, when we're talking about that executive committee, they don't have the authority to change the approved budget. The CEO registrar might take something for discussion to them and see, is this something that there would be interest in, but they can't make a change of the budget. The accounting manager, who you'll meet later today, that's Sharon, she reports against the budget quarterly to the Governance and Audit Committee. And then we attach that report to the CEO registrar operational report, so you can see where we're at. We also do our best to highlight material variances in revenues and expenses when we do that reporting, because sometimes it can look like something's really alarming when in fact it's not. For example, if you're reporting in the first quarter, the budget numbers would be divided by the 4 quarters. They're actually divided monthly, but there would be charges that are incurred in January for the full year. So that would inflate what we've spent versus the budget, but that's an easy thing to explain. So we try to offer those explanations on those variances so that you're not alarmed that something went way out of budget. And then there are times when things just unexpectedly go out of budget, and we just explain how that happened or why it happened. The last piece of this part of the presentation is monitoring performance. This is a really important role of the board as well. So ultimately, the board is responsible for evaluating whether the operations got us to where they sent us. So there's 3 key questions that the board can ask. Where are we compared to where we said we would be? So you set the strategic plan, the strategic goals, and did we get there? That's great. If we didn't get there, why? So again, you're not always going to get to your goals, but sometimes there's a reasonable reason. I would argue that probably 3 years ago, we didn't meet a lot of the goals that were set a couple of years before that because all of a sudden COVID happened. And that's a reasonable reason we had to defer a lot of our other work at that time. So we tried to pick it back up then. Second question is, how do we measure up? So this is really about how are you going to measure things? Do you have something to measure them against? Key performance indicators are probably the best way to do that. If you build a key performance indicator into the goal at the start, then you have a clear measurement system. If not, though, we can do things like benchmarking and surveys. So for things like satisfaction and communication, we've talked about key performance indicators there, and we do things like open rate, response rates, but ultimately probably surveys offer us better feedback on that type of work. So there's different ways of measuring. And then the last question is, how well did the council and the management perform? So the council does do an annual self-assessment, and this is done against a council competency matrix that has been built. Council competency matrix is there to identify the skills that are a priority for us to have on this council. And then the council members are asked to do the self-assessment to identify where their strengths and weaknesses are. And that really helps too when it comes around time to nominations, because the nominations committee, the governance and audit committee doing the nominations, reviewing the nominations, can identify if there's a gap in knowledge around the table that we really would like to have filled. Second piece of evaluations there is the CEO performance evaluation. So this is really important for your CEO registrar to have feedback on how well the council feels the management and the staff are performing, how well operations is going. Without that, the CEO registrar is really just left to make assumptions on the work that they're doing. One way of bridging that throughout the year is we do present that quarterly operational report to you guys at council. Hopefully you've had a look at that, but if not, we'll look at it today in the meeting. And by motioning to accept that operational report does give feedback to the CEO registrar that the work that's being done throughout that quarter has been reasonable, it's on track with strategic priorities, that type of thing. But the annual performance evaluation is really an important piece as well. So now that I've just talked for 35 minutes, we're going to take a little break. But before we wrap up this half of the presentation, just if there's any questions about board governance or the committees or the finances, I'd invite those now.
Nope, just a learning curve for me on not wearing both hats.
Yes, it's quite challenging. Yeah, it's a really common issue, particularly, again, for registrant members. For public members, they're coming with a bit of a different perspective. Chin can maybe speak to that. But I think for registrant members, it is hard to remember that you're not thinking about yourself as a professional. That's actually, I think, easier, but more we're used to thinking about our practice, right? We're thinking about our location and how it affects our business, but we're talking more globally.
Scope of practice changes, all those things are really association issues.
Yeah, totally. As you say, it's a learning curve, and I think we have a good organization. We have a good board. No one's going to jump on somebody. I think the norms being there really helps with that. Everyone's there to support each other. So if somebody does start thinking that, I think there's a way to respond in a constructive way. So the second half of this presentation is an introduction to the regulatory framework. And I don't know if you guys will notice, I'm much more comfortable in this half of the presentation. This is where I live every day in my work. I've worked at the college for just over 7 years. This is all that I've done. So even when we were college and association, I was always on the regulatory side of the business. Regulatory framework, I could go on and on and on about, which I know is hilarious because people, when I tell them what I do for a living, they're like, whoa, That must be exciting. It's not that it's exciting, but it is interesting to me. My point of saying that is I've worked on it for 7 years. I live in it every day. There's still things that come up that I have to look up. It's not just at the tip of the tongue. It's a lot of legalese. It's challenging stuff. So there's no expectation that after a 45-minute presentation, anyone joining this meeting will become an expert on the regulatory framework of the College of Opticians. The goal here really is to offer this introduction to, like I said, the language, a general introduction to the topics that commonly come up at the council table, and to give registered members an idea of how the things that they may already be aware of as a practitioner apply differently when you're talking about the organization versus when you're talking about the practice. And then for the public members, like I said earlier, to give them an introduction, perhaps they come from outside of healthcare and never seen any of this. So to give them an idea just basically of how this profession is regulated. So this is a brief look at what we're going to talk about in this half of the presentation today. So we are going to go through an overview of the Health Professions Act. This is really the biggest piece of legislation that we're concerned with. We'll talk about privacy legislation, the HPRAR, which is brand new legislation. That's a good example of an unexpected change, our professional regulations, and then the standards of practice and code of ethics that we draft in-house. And then I do give an overview of bills, acts, and agreements. This is really about demystifying language and terminology that comes up around the table that we take for granted, that new faces at the table may not be well versed in, which is totally reasonable. So the Health Professions Act, we commonly call the HPA, but we sometimes also have a flip and call it just the Act. The reason why is because this is the primary piece of legislation that we're governed by. It's implemented by our provincial government, and it provides a common regulatory framework for all the health professions in Alberta. So we're one of 30 health professions that are included under the Act. It's particularly relevant to the organization rather than the practitioners because it sets all of the regulatory requirements and the role of the college. It may also be useful for practitioners to help them understand those requirements and what we do here at the college level, but again, it is primarily used by the organization. The Act was developed to regulate health professions using a model that allows for non-exclusive overlapping scopes of practice. This is always an important piece that we bring up to remind that within the Act, multiple professions can have the right to provide the same services. So the restricted activity is not owned by any one profession, and the Act is specifically written in a way that prevents that from happening. So a common example that government presentations always use is blood drawing. There are many professions under the Act that are allowed to perform that restricted activity. For us, opticians are allowed to dispense corrective lenses, but so are optometrists and ophthalmologists. So no one has ownership over that restricted activity. There's also nothing preventing another college from requesting that permission be added to their scope. Again, no one owns it. So it is under this Act where the professions are organized into the regulatory bodies called colleges. This language is confusing. Colleges typically the common language is that colleges educate. And so we do get calls at the College of Opticians about how a person can go to school to become an optician. That's not what we do. It's just the language that's used. We are the regulatory body. We're the regulator, but we are called colleges. That comes from the Act. Colleges are delegated powers of authorities and self-governance through this legislation. So basically the way that it's set up is it allows the health professions to self-regulate. What that means is the government has identified that the people involved in the profession have the best idea about how to effectively regulate it, and they're offered the privilege of doing that through self-regulation. But the Act makes sure that the profession remains accountable to the government, and ultimately, again, there's that moral ownership piece, the people of Alberta. The Act requires the college to carry out governance responsibilities in a manner that protects and serves the public interest. That piece is always driven home. That is our job. We are here to protect the public, to protect the patients. The Act is long. It's an arduous read if you're planning on diving in there. There are 15 parts to the Act, and I won't go into all of them, but I'll just note Part 0.1 is a new part of the Act, now comes before Part 1. It's the Health Services Restricted Activities section. This used to live in the Government Organizations Act. It used to be Schedule 7.1 there, and it's the list of activities that the government has deemed dangerous enough that they should only be performed by regulated health professionals. So those restricted activities may only be performed by us or another profession. Part 1 is governance. Part 2 is registration. So that tells us all the elements of registration that are common among all the colleges, including Section 46, which is mandatory registration. That comes up at the table quite a bit. Mandatory registration boiled down means that if a person is qualified to be a member of the profession and is providing services of that profession, they must be registered with the college of that profession. Part 3 is continuing competence and practice visits. Again, this is only the parts that are common to all professions. Our profession-specific ones are located elsewhere. Part 4 is professional conduct, so that's where I live for discipline. Part 5 is business arrangements, so we don't dive into that very often. Part 6 is other matters. The only piece that comes up in Part 6 ever, in my experience, is Section 118, which is assessing incapacity. The college does have authority to assess incapacity of a registrant for the purpose of public protection. Part 7 is title protection. The title of optician and registered contact lens practitioner and a few other ones are protected. Title protection is under the Act, but also more specifically, it's in our standards of practice. Part 8 is where it dictates regulations, bylaws, codes of ethics, and standards of practice. So it tells us what we have to do for those. Part 8.1 is really just the minister's role. Part 8.2 is patient relations program and funding for treatment and counseling. This came out of Bill 21. We're going to talk about bills later, but it was a bill to support or the protection of patients from sexual abuse and misconduct at the hands of practitioners. And part of that was that all colleges have to have a patient relations program and funding. So what we have to have is funding that is available for any complainant that has allegations of sexual abuse or sexual misconduct. Regardless of the outcome of the complaint, we have to offer them funding for treatment and counseling. Part 8.3 is college websites. So it tells us we have to have a website and sets out the minimum requirements. Part 9 is nothing. It's like consequential amendments and coming into force. Part 10 is the big piece here. It's profession-specific provisions. So Schedule 16 under Part 10 is the profession of opticians, and it's specific to our profession. So that's a piece that you might actually look at more often. The next thing I like to look at is a brief overview of privacy legislation. So ultimately, there's 3 pieces to look at here. The first is the Health Information Act, which we will refer to as the HIA quite often. And it dictates how regulated health professionals, so in our case, opticians, collect, use, and disclose patient health information. The goal of this legislation is to strike a balance between the protection of privacy and enabling the appropriate amount of information sharing to provide health services and manage the health system so the health system doesn't crumble. And then it's supplemented by something called the Health Information Regulation. So that is a document that regulates matters pertaining to the Health Information Act, including things like designation of custodians, exclusion from the definition of health services, information manager agreements. That the HIR, the regulations, is, like I said, supplemental. And it's really for regulated health professionals to apply the Health Information Act to their practice. The Health Information Act is relevant to the college because we have to enforce it. So as part of under Part 4 of the Act, receiving of complaints, there are often allegations of breaches of the Health Information Act. We would have the authority to pursue those types of complaints. So that's where the Act comes up for us. I also include PIPA and FOIP here. So PIPA is the Personal Information Protection Act. And PIPA applies to the private sector. So it doesn't apply to practitioners collecting health information because that's the Health Information Act. And it doesn't apply to the college because we're a public body, but it would apply to, for example, optical employers. And for our registrants, it would apply to how their employer collects, uses, and discloses their personal information that they've collected reasonably as an employer. So that one doesn't come up that often, but it's there. And I put it there too, just because, if you're in business and you use PIPA, you might wonder why we don't apply it. This is why it doesn't apply to us. FOIP is the Freedom of Information and Protection of Privacy. This does apply to us. It protects personal information collected by public bodies, which the COA is, and their employees. And so this, the simplest example here is the COA collecting registered information in accordance with the Health Professions Act. So we're required to have certain information about our registrants on file, but we also, under FOIP, have responsibility to protect that information to the best of our ability. So we have to have reasonable protections in place. We also don't collect any information similar to a practitioner that we don't need. So you only collect the information that you reasonably need. So this is the new slide. You guys are the first one. I give this presentation a bunch. I give it to students and I give it to council. I give it to a few different groups. And this is a brand new slide. Health Professions Restricted Activity Regulation came into force in March of 2023. It is a result of Bill 46, one of the many things that came out of Bill 46. But this is talking back to the restricted activities that I mentioned earlier. So in Alberta, the government has set this list of restricted activities that they deem to be high risk. So only authorized professionals can provide those services. The restricted activities used to be housed in the Government Organizations Act, which was Schedule 7.1, but are now listed in the Health Professions Act, as we talked about earlier. Part 0.1 is that list now. So that list just shows you the names of what the restricted activities are. This document, the HPR-AR, is profession-specific application of the restricted activities. So this document is organized by profession and notes which of the restricted activities each profession is allowed to provide, and then sometimes gives a little bit of supplemental information if there's like a caveat or a unique application of how they can provide those services. So as I said, this came into effect in March of 2023 from a bill called the Health Statutes that became the Health Statutes Amendments Act. It was introduced in 2020. So that gives you an idea of how long things can take to trickle down from the introduction of a bill. The next document is the Optician Profession Regulations. This one we are really bad for. We call it the regulations or the regs often, which if we didn't give you this slide ahead of that, that would mean nothing to you and that would be very fair. It's more confusing now too because of that HPR-AR. It's also a regulation that we may talk about often. So we will probably try to call this the Optician Profession Regulation, but that's just not what we commonly call it. So what this is that each profession under the Act has profession-specific regulations. So our regulations currently include defining register categories. So that's what I mentioned earlier. So we have a general register, a courtesy register, and a provisional register. The reason we're allowed to register people under those three categories is because they are defined within our regulations. It also includes application requirements, restricted activity application, title use, practice permit requirements, our unique process for continuing competence and alternative complaint resolution, as well as reinstatement procedures for Alberta opticians. The reason I say that this is what's currently in our regulations is because they are going to change. What happened with Bill 46 is it required things to be moved from regulations into standards of practice, including the continuing competence program and a couple other pieces, as well as Bill 46 having that HPR-AR document. Those profession-specific applications of the restricted activities live there now. But the last thing that will be changed is all of the professions regulations. So right now there's some redundancy, there's some duplication there, but they have to do it in order. Our standards of practice revisions were just accepted effective May 30th. Once everyone's standards of practice are done, our understanding is that then the regulations will be updated. So changes are coming. Then the other piece I'd like to mention is that our regulations also build on Part 6 of the Act. They give the organization more guidance on our duty to provide information. So this is in Section 31 to 33. And it lists the information a regulated member is required to provide to the college and the information the college may disclose with respect to a regulated member when a member of the public requests that information. So again, thinking back to the last slide, we only collect the information we're allowed to collect and we need to regulate the person, but then they also give us guidance on how and when we need to release that information. So for example, we do not have to release the practice location for a registrant. So when you look up an optician on the registration verification place on our website, it does not necessarily tell you where they work. The optician can choose to disclose that information if they want to, but we don't just readily give out that information without their permission. The next piece is standards of practice and code of ethics, and this is a pretty significant shift from the other documents. Those other documents are written by the government, and we are told to enforce them. Standards of practice and code of ethics are written here. So as a council member, you guys will have ownership over these documents. And when I say you'll have ownership over them, I mean like they will come to you for final approval of a draft before it is sent into the minister's office. Standards of practice, what will happen is if we choose to make revisions or if we're mandated to make revisions, we do so. It goes before our registrants for feedback. We don't have to apply that feedback, but that's the practice that we employ to get registrant information, registrant feedback on the topic. The standards are then brought to, in this case, our registration and competence committee. They would, they would have reviewed it before it went out to the registrants at that point, but it would come back to the registration and competence committee to consider any feedback we got from registrants, at which point we would consider it to be a final draft. That draft would be recommended to the council to be sent in for approval at the minister's office. Once a standards of practice is sent into the government sends it to stakeholders as well for consultation. So for example, I think in the last month, I've reviewed 4 different standards of practice from other colleges. They come out to all the other health colleges for feedback. The minister's office, again, can choose what to do with that feedback, but often they will come back with questions if there are concerns based on the stakeholder feedback, and we may have to make some revisions or whatever. Ultimately, though, then we would get ministerial approval on our standards of practice. So again, I mostly just go through that procedure to inform, we can't just change our standards of practice. It is quite a procedure, so we try to do it in as organized a fashion as possible. And then there are other times when it's really fly by the seat of your pants, which is typically when the government tells us you have to make this change and they give us a deadline for it, and we have to just make it happen. The standards of practice is the minimum enforceable level, minimum acceptable level of performance qualifications and professional practice. I always go over this whenever I talk about standards of practice. I think it's particularly important for registrant members of council to hear that and remember it when we're talking about enforcement. A lot of the time we'll hear the feedback, well, I would never do that. I would do this, this, and this. I would do much more than that. That's not enough. And that may be true if you're talking about what you would do or best practice, but we're not talking about that. We're talking about a minimum enforceable standard that ensures a minimum level of competent, safe, ethical care. So that's the consideration. Again, you're not thinking about what would I do? You're thinking about what, if it wasn't done, would create an unsafe environment for the patient, would create an unethical situation. So we're really talking about setting those minimum standards. Sometimes that doesn't feel good. Of course, we would rather know that all practitioners meet a best practice level of standard, a level of care, but the college needs this minimum level so that we have something that is enforceable. So again, we're here to identify unsafe or unethical care. We're not here to identify the best practice. The little caveat there that I hope makes people feel better is that another part of my job at the college is considered practice advice. And really what that piece is there for is to help offer, I'll just tell you, a registrant phones me and says, this is a situation, what should I do? The first thing I tell them is what they are required to do in accordance with legislation and the standards. So that tells them what the minimum level of care they can provide is or what they have to do. The second part of that conversation is always, this is what you should do. This is what I would do. This is what I would recommend you do, which is very different than what is the enforceable standard. But we do have that discussion. We do offer that information quite regularly to our registrants. The Code of Ethics is another document developed, like I said, within the college. It includes the basic obligations specific to professional conduct. And really the piece here, I think the most important is that all the registrants have an ethical obligation to the public, the profession, and the college. So we are looking at revisions to this document to make that a bit more clear. And there's some discussion about having a national code of ethics for opticians, because really there's no need for that to be province specific. So that's on the table at the national level. Failure to uphold either the standards of practice or code of ethics can be deemed unprofessional conduct. That's bringing it back to the organizational level. When we're investigating a complaint or an allegation of unprofessional conduct, breaching the standards of practice of code of ethics would certainly constitute a finding of unprofessional conduct. The last piece of this part is, this is sort of jumbled slide, but I put it together, bills, acts, and agreements. This is really, again, these are just things that come up around the table, things that come up in discussion and can be confusing, rightfully so. So a bill proposes new legislation or changes to existing legislation. It passes through several stages to become law in the province of Alberta. And then once a bill is passed by the Legislative Assembly, it becomes law after receiving royal assent. It's then referred to as an act. However, in discussion, we often still refer back to the bill. And part of the reason why is things like this. Bill 30 enacted different changes than Bill 46, but they're both called the Health Statutes Amendment Act. So that causes its own confusion. So for example, I think I said earlier in this presentation, Bill 21. Bill 21 was the bill that then implemented an act to protect Alberta patients, but that didn't create a new act. It made changes to the Health Professions Act. So all of that's very confusing. It actually becomes simpler to then just keep referring to Bill 21. But if you weren't around during Bill 21, it causes confusion around the table sometimes. Once it's an act, it comes into force either upon proclamation or a specified date. Sometimes they'll come with a specified date to give the government room to make other changes that they need to. But if neither is indicated, once it gets that royal assent, it comes into force. So it's like an immediate thing. Included this portion here of the recent bills that affected the COA. So Bill 11 was the Fair Registration Practices Act. And this changed some things organizationally for sure. We have to do some different annual reporting than we used to have to do. And we are subject to a fair registration practices audit. We anticipate that's coming soon. They started out with the bigger colleges or those that they were prioritizing. For example, the nurses got their audit done, and that was a priority for our government because they want nurses registered quicker because we have a major shortage and our healthcare system is struggling. But the Fair Registration Practices Act did change some of how we collect information, how we share information with the government, and our reporting responsibilities. Bill 21, as I said earlier, was an act to protect Alberta patients. This enacted quite a bit of change related to protecting patients from sexual abuse and sexual misconduct at the hands of registered health professionals. In particular, for the college, it required mandating education of our staff, our council, and our registrants related to trauma-informed care. Majorly, that the resources and funding for counseling and treatment, that was a big implication for the colleges. We have to have that in place and ready to go at any time. And then it also enacted quite a few changes related to the complaints and discipline process. So for example, if a registrant is canceled for a finding of unprofessional conduct related to sexual abuse, that cancellation is mandatory. The hearing tribunal has no authority to give them a different sanction. They must cancel them. And then the college can never reinstate that person. That's a permanent cancellation. And that's quite a difference from before this act was in place, before this bill was presented. Bill 30 and Bill 46 both became Health Statutes Amendments Act. Bill 46 was a major influencer of the college's work over the last 2 to 3 years. It is the one that required the separation of college and associations across the board. So there are no longer any combined organizations in Alberta. One of the other interesting pieces of Bill 46 that's talked about a little bit less is that it also invited the opportunity for colleges to amalgamate. It did not mandate it, which has happened in our sister province there in BC. So in British Columbia, they have mandated amalgamation of health colleges. So they are about to be a college of physicians, a college of nurses, a college of dental health professionals, and a college that has everybody else in it. So that's where Opticians would end up if the same thing were to happen here. That was mandated in British Columbia. Here, they haven't gone that far, but in Bill 46, they did invite the opportunity to amalgamate. No one has taken them up on that invitation. And it's just an interesting trend that we're following because it is curious. If it goes well in BC, they likely will consider it out here and what the implications are of the fact that no one looked at the opportunity. So again, today, when you review the strategic plan draft, you will see in there that we've included basically being prepared for amalgamation because we don't know if it's happening, but it would be irresponsible to ignore these signs that it could happen. Bill 10 is the most recent one we went through, the Health Professions Protecting Women and Girls Amendment Act. This one included some specific requirements for the colleges to implement standards of practice related to female genital mutilation. That was an interesting one for the college to navigate because there's really no imaginable circumstance where an optician would be involved in anything even remotely related to female genital mutilation. That's so far from the work of an optician. But it is a good example of where, because we are under the Health Professions Act and we are considered equivalent under that act to all of the other colleges, that we have to implement the same changes. So we got some interesting feedback when that standard draft went out to our registrants. There was a lot of confusion there. And again, we just try to make sure our communications are clear on why those types of changes are made. In this case, it was a requirement of this Protecting Women and Girls Act. The other piece I include on this slide is to talk about agreements. So the CFTA and NUAPTA, the Canadian Free Trade Agreement and New West Partnership Trade Agreement are trade agreements that create frameworks for trade. They're both meant to enhance the flow of goods and services, investments, and this is the important piece, labor mobility. So the Canadian Free Trade Agreement is for across Canada. NUAPTA is an agreement between BC, Alberta, and Saskatchewan. And the reason I mention these is because, like I said, about that labor mobility piece. So that affects our mutual recognition agreement. It's why we have the mutual recognition agreement. What this is the COA has entered into an agreement with all the other provinces in Canada except Quebec. This agreement was entered into in 2000, and it states that we will accept registrants from another province based on their registration and good standing with another province's regulator. So in accordance with our regulations, we're allowed to register a person for 3 reasons. Either they meet our registration requirements, so in our case, that's certain accredited education, a national licensing exam, and jurisprudence, or they can prove substantial equivalence, and we can do that through a prior learning assessment and recognition program administered nationally by NACOR, or we can have them come from an equivalent jurisdiction. So registration requirements, substantial equivalence, or equivalent jurisdiction. So equivalent jurisdiction is what we're looking at under the mutual recognition agreement. And really what it means is, for example, if an optician's registered in Ontario, they're in good standing there and they want to move to Alberta and practice here, all they have to do to qualify for registration is prove that they're in good standing in Ontario. So we do that directly from college to college. They will send us a letter from the College of Opticians of Ontario directly to us. We did the same thing to other colleges. And then we do not look behind their license there. So we don't need to know how they got their license there, whether they went to school or they went through PLAR or how they got it there. We trust that the other colleges have done their due diligence in the initial registration, and we recognize that it's a substantially equivalent registration process to our own. It is important to note, because I say Quebec's not included, we do all of the 9 provinces within the agreement accept opticians in the same way from Quebec. We use the same standards. They haven't signed into the MRA because their provincial legislation doesn't allow them to accept registrants in that way, but we recognize that they have actually probably higher registration standards than any of the other provinces. So we do accept their registrants if they're in good standing. This also is an important thing to bring up because many of the national initiatives we enter into with NACOR stem from this agreement, because it's important for as many projects as possible to apply across Canada to uphold the MRA. So if we start changing registration requirements, like for example, if one of the provinces stopped using the national licensing exam, that would greatly affect the mutual recognition agreement, because we would then have to assess whatever they're using for a licensing exam, and it would make it a lot more tricky. So that's really supportive of national initiatives, national projects with NACOR. So that's the end of this part of the regulatory framework piece. So what I recognize is one of the things that we offer for students when we go to the presentation is a brief introduction of who we are. I thought it might be useful for you, again, just thinking about things that come up at the table, like the staff names might come up at the table and you guys have never been told who the staff is. So we do operate with a small staff. So Ruth has been with the college for several years, and she was our registration administrator. Her title now is registration and complaints coordinator. So she is really our front line. So our registering council members probably do know Ruta. She's the one who will typically be the first one to answer the phone, the first one to answer an email, especially when it comes to registered inquiries, because she's the one who deals with registration and renewal with the continuing competence program primarily. And also she is our feet on the ground in Alberta for the national licensing exam. So she's the exam coordinator here in Alberta. So the students also get to know her early on. So that's Ruta. She is also the primary staff administration person on the registration and competence committee. I mentioned that earlier. So if you're on that committee, Ruta is the one there taking your meeting minutes, posting meeting materials, sending out reminders to the committee members for that one. Christy Murray, I introduced her at the start of this call, but Christy Murray is our operations manager, and she has been at the college. Christy, I don't even want to say, I don't know how long you've been here now. She's been at the college longer than any of the other staff.
Since 2005.
Since 2005. So Christy's been here almost 20 years. So Christy has the best historical knowledge of the organization. That's a great resource. But Christy is kind of a jack of all trades for us. You can step in, Christy, if you feel I'm overstepping, but she's done worn a lot of different hats and currently is in charge of operations. And then as far as with council, she really is the primary staff to do the administration for all of the council business. So agendas, meeting minutes, and like I said earlier, organization of all those types of things. So if you are missing a per diem check, if you need a hotel booked for a meeting, any of that kind of work she does. And she's also always going to be at your council meeting because, like I said, she's taking minutes and helping with anything administrative at those meetings. Then there's me. So yeah, I'm the Deputy Registrar Complaints Director most of the time. Right now, I'm the Acting CEO Registrar. and Deputy Registrar Complaints Director. So in my role as sort of the second in command to the CEO Registrar, the reason why I'm the acting Registrar and CEO is because we have policy that the CEO has to appoint a designate. So in the case of their departure, we have somebody on staff who has at least enough working knowledge to get us through a transitionary period. So that was me. And so I was appointed to that role in the interim. We also have one other person on our team. That's our accounting manager, Sharon. Sharon is unique because she's not a staff member per se. She's a contracted worker, but she's not in the office answering phone calls, that type of thing. But she is our accounting manager. So she's contracted to do that work with the CEO registrar. So Sharon's a very helpful person to have around. She's made some really effective changes for our finances at the organization. The other couple things I wanted to mention that come up around the table are NACOR. NACOR is the National Alliance of Canadian Optician Regulators. Our registrant members are typically very aware of NACOR because they had to take their national licensing exam through NACOR if they've been licensed since NACOR has been administering that exam. But NACOR is more than just the administrators of our national licensing exam. It is a collective of all of the regulators from across Canada where we can work together on interprovincial projects. It's a great way to, again, like the Federation in Alberta, we can pool resources and work on projects that affect everyone across Canada. One of our primary examples of that is PLAR that I mentioned earlier. The Prior Learning Assessment and Recognition Program was originally built to assess the credentials of internationally educated applicants for registration in Canada. And it started out being administered by the provinces. NACOR built it, and then we were all administering it. It became overwhelming for some provinces, and there was a conflict for some provinces. So NACOR is administering PLAR now. So if an internationally trained applicant comes to Alberta and says, I want to apply here, we send them to NACOR. NACOR assesses their credentials and then sends them back to us for registration. So that's a great resource for us to have. And at NACOR, you'll hear from Jody Dodds, she's the executive director there, and Jamie Hay, who is the national exam coordinator. So we talk about them often and we work with them often. So you will hear about them. The last piece is the association piece. So as I mentioned earlier, we have separated. We used to be the ACAO, the Alberta College and Association of Opticians. We are now just the College of Opticians of Alberta. Part of that separation process was that some of our council members agreed to be on a steering committee to build a new provincial association. And our organization agreed to support that work by funding it. So last year, we gave a significant funding to the startup of that organization. That's now the AOA, and they're running independently from the COA. That was sort of the last piece. We gave them the funding, and then there was full separation. The other way that affected our college was we did do a significant reduction in our registrant fees. So we reduced registrant fees by 20% when the separation, in the first year the separation was completed, which was last year. And so now we're rebuilding from that fee. So if you're looking at historical budgets, there's a significant change in our member revenue, and that's why, because there was a big dip a couple of years ago. So the AOA exists now. That's our provincial association. They're still, I think, getting their legs. It's still really at the startup phases. And as far as our registrants are concerned, there is also a national association. This is maybe also important because, like I said earlier, if discussions come up and we're wading into association business, that really is not ours to have. The Alberta Association and the the OAC, the Opticians Association of Canada, is really where we could refer that type of business. You know, if something comes to our attention, we do have a good working relationship with them, so we could, you know, alert them to something like that, even though we don't have the authority to pursue it anymore. So that's it. That's an hour and 35 minutes of me talking, which is plenty. Yeah. So I guess if there's any questions, I mean, you don't have to ask them here. Like what we do with students with this presentation is we give it to them. They never have any questions. And then we invite emails, and usually we field some emails from them after. So feel free to reach out to me if anything comes up after the fact or after the council meeting this morning. If you're if it conflates any of this information actually participating in the meeting, feel free to reach out to me anytime with questions about it. Is that satisfying?